Welcome to Expert Views on ADR Ever, a podcast about simplifying the traditional African method of settling disputes or appropriate dispute resolution ADR in a bid to attract more and more users to settle their disputes or conflicts with mediation, arbitration, collaborative law, restorative justice, negotiation, conciliation, and early neutral evaluation. My name is ChinweEgbunike, a postdoctoral fellow at the University of Brighton, United Kingdom, and a fellow of the American Bar Association section of dispute resolution. I am delighted to welcome Marc Sheridan to the EVA show. He is a partner at Markus and Sheridan LLP, past chair of the Westchester County ADR Committee. He trains human resources professionals, business groups, and owners in the New York City metropolitan area on using dispute resolution techniques in the workplace. Marc O authored the 9th Judicial District Presumptive Mediation Program rules and the Westchester County Surrogate Court Presumptive Mediation Program. He wears many hats, so I've left the link to his profile below. Thank you so very much, Marc, for coming on the show. Let me stop sharing now.
Thank you, Chinwe, for having me. Appreciate it.
Thank you. So without further ado, the first question is, what is collaborative law and its impact specifically in New York?
Sure. So collaborative law is really, Chinwe, a solution-oriented approach to resolving disputes. It's really unlike in other types of dispute resolution processes. It's about the professionals working together, we call collaboratively, to sort of help the parties restore communication, help them solve their problems without solving them for them, and helping them to avoid the collateral damage associated with conflict. It's, as you probably well know, its impact in the US and it has an impact worldwide as well. Just by sort of introduction, it started back in the 1990s with a fellow named Stu Webb out in Minnesota, the state of Minnesota here in the US, who was a trial lawyer for family disputes, matrimonial disputes, as we call them. And he effectively got tired of what he calls performing. As litigators, I have a litigation background. Where my idea of negotiation was to write a letter back to you when you complain, telling you why you're wrong. And when you respond to me, write another letter telling you why you're wrong again. And the focus for Stu Webb and others as from the genesis of what he created was he got, again, tired of performing in front of juries and wanted to help parties really help them resolve their disputes.
Okay, thank you so very much. So, so you've touched on the next question, that's the history. So is there any measurable difference or impact on the cost and time frame for settling disputes under collaborative law compared to litigation and, of course, mediation as well?
Sure. So I come from my background's non-matrimonial. Collaborative, as I said to you, started in the matrimonial space. I started about a decade or so ago focusing using collaborative process outside of matrimonial because my bailiwick is in employment and closely held businesses and the like. So I looked at this as a process really to help parties in resolving disputes outside of court, as you well know. And so there is huge cost savings with compared to judicial litigation here in the U.S. and particularly New York. There's been a study, I think the Wall Street Journal back in, it's going back into more than 15 years ago, did a study of it showing it's about roughly a third of the cost of a fully litigated type of litigation, which is tremendous. And the also element, not so much, like you said, from a time perspective. So an average litigation here in the U.S., and particularly with the COVID pandemic, can take between 3 and 5 years. Sometimes longer. And if it's appealed, another couple of years after that. So if you're in a business-to-business dispute, that's a long time to get not resolved. If you're in a personal dispute, like a matrimonial, That's a
Yeah.
really long time not to get resolved.
Yeah.
And so with the collaborative process, we control the calendar, so we control the time. So I'm doing a collaborative case right now where I've scheduled meetings after work. I can schedule meetings on the weekends. I can control that time, right? I got a lot of control of when I do that. In court, I don't know if it's similar from your experience, but you can go to court, you can spend several hours waiting for a judge, but pre-pandemic, right? And then only to be told you have to come back. Or even on Zoom now, if you're sitting on a call, things don't move as quickly in the court process as they would outside. So it's really, my cases, when I talked about 3 to 5 years, I've had cases resolved in 3 months. So it's a huge time and cost savings in that respect.
Yeah. So how about when you compare it to mediation, because mediation is usually cheaper.
So we don't talk about collaborative being cheap, okay? Because it's not, okay? It's you're hiring professionals to help you work through a lot of difficult issues and conflict, understand your interests. It's a structured negotiation. It requires a lot of, what we call active listening and using those skill sets and exchanging information. But it's short-circuited by, in comparison to a law and discovery process and litigation. Mediation typically happens in the commercial context, Chinwe, after litigation has happened. Okay, it's rare. Most cases have been into litigation at a period of time where there's been an expense of time and money. And then they've come to the understanding either through a court process that's mandatory or through electively that they're going to go to mediation. So yes, if the mediation is done correctly, it can be resolved sometimes in a number of hours, sometimes in a day or two. And that's a cost savings. But if you look at from the beginning of when that conflict arose to when that mediation ended, there's pretty much the same expense that you're going to look at in terms of time and money.
Okay, thank you so very much. You mentioned professionals in collaborative law. Are they lawyers? The professionals, must they be educated? Can you tell me more about who can train as a collaborative person there?
Sure. So collaborative in particular, and I'll mention to this, there's 2 main organizations for collaborative, the International Academy of Collaborative Professionals, which focuses mainly on matrimonial, and the Global Collaborative Law Council, which is focusing on collaborative outside of the matrimonial sphere, which they call civil or outside of matrimonial. Usually, collaborative usually requires people with professional licenses. So lawyers, particularly in the matrimonial, they use a team approach in many cases, in many states. And so they'll use what they call coaches. Those are people licensed usually as a licensed therapist or psychologist or psychiatrist, depending on their licensure. And then a financial neutral, usually to help parties in dealing with sort of the dispute over the financial aspects of it. And that's someone that is usually licensed as well, whether it's a CPA or a financial planner or what have you. In my area, they have different names for those folks, but they all tend to be licensed professionals.
Okay, thank you. So is it regulated? What do I mean by that is, if you're trained in New York as a collaborative law personnel, can you practice elsewhere?
So the answer is no.
Okay.
I
so you
can't,
have to get the training from that state.
So it is geocentric. So I happen to be admitted in New York State and state of Connecticut here in the US. So I can practice law in those 2 states. Unlike mediation, that you're representing parties in collaborative, right? So it's an attorney-client relationship. So I'm bound by my licensure rules and ethical rules under the bar association, right, for the bar. And so it's not superseded by UCLA or the from Collaborative Law Act or something like that, but that you're bound by. Same thing for I imagine for other professionals that they're licensure, they can't practice in different states.
Oh, okay. Okay. All right. Thank you so very much. So, can you please simplify the differences and similarities between mediation and collaborative law?
Yeah, so I'll say this with a caveat. In my world, or what I would call the quote unquote civil or commercial world, most of my mediation work involves parties who have counsel at the table, which is quite similar if you think about it in terms of collaborative, because there is parties, represented by counsel, and usually there's a facilitator, or like we talked about, like some people call them a coach or facilitator, which is effectively like a mediation type of role in facilitating that conversation. The difference predominantly is this: if I represent a party in mediation, okay, I'm usually not limited by that scope of my representation, Chinwe. So if the mediation breaks down, for example, doesn't result in a resolution, I can litigate, right? I can continue to litigate. I'm not limited in my scope of representation. In collaborative, we have limited scope representation. Okay. So I'm only hired for settlement purposes only for this collaborative law process. And as you probably well know, one of the hallmarks of the collaborative process is a withdrawal provision, which basically says this: everybody's focus is on settlement. If it doesn't settle, I'm not going to represent that party in a litigation. Okay. And so the concept is it's not a disqualification. What it is basically it's an agreement that I'm going to limit my scope. And I do that in my retainer, that I'm limiting my scope of my representation. And in fact, from an ABA perspective, it's been approved that that's okay to limit the scope of your representation. Your role's different. The lawyer's role in mediation is, I think, some more of an advocate. Good advocates listen well. I think, but our role is more supportive in collaborative. It's really to help the parties have a voice in that process in dealing with their conflict, and help them identify their interests and options that work for them. And unlike mediation, we'll use, the neutrals. We'll use a financial neutral. I've used a business neutral, evaluation neutral, regarding a business-to-business dispute, things like that. There's a lot of malleability and flexibility with the process. So I think it's a little different in that respect.
Okay, thank you so very much. So you've touched on the models that can be used in collaborative law.
Sure.
So can it be used to settle workplace disputes or any kind of conflicts or disputes?
So it can. I've had success using it in employment. We call employment disputes or workplace disputes. Collaborative has a real benefit for interpersonal disputes. Okay. So closely held businesses, family businesses, estate disputes, vendor-vendee, where there's a relationship over time. Those are good business to business, where they want to continue a partnership, but they're having some, difficulties. I've used it with lawyers. I've used it with doctors. It can have, when you have a business, when you mention workplace, so by background, I'm an employment lawyer. We tend to really identify ourselves, right, Jimmy, by what our names, where we live, and what we do. And so people are very personalized about, though, that's an interpersonal conflict, what you do. So it really kind of lends itself to a very well to collaborative process.
All right, thank you so very much. So can collaborative law be utilized in all cities or states in the US?
So the short answer is yes. It can be used anywhere. We practice, I think, collaborative law now in 20 countries around the world. So it can be used in a lot of different areas. Within the United States, there's something, and I think you probably spoke to one of my colleagues about this. There's something called the Uniform Collaborative Law Act, which is called UCLA. And that's here in the States, what we do is we sort of codify by statute a certain process or practice. And collaborative, through the folks who've really, like Kevin Scudder and other folks, have really spent a lot of time working on this. There's a codification, I believe, about half of the United States, almost 20, I think about 25, maybe more. I think it is more. When it's not codified by statute, it's by agreement. So here in New York, we haven't codified it by a statute.
Oh,
But it's practiced in terms
why?
of by
Sorry.
agreement. What's that?
Why in New York?
Hmm. Um, let me be. So there are collaborative teaches you about interest, Chinwe, okay? And it's about
Yeah.
interest negotiation.
Mhm.
Um, Lawyers, like other people, have very different interests. And
Mhm.
so I think the trend has been to more codify it as an appropriate process. I think for some people, there's a reticence about something new. I mean,
Okay.
here in the States, we've known the way that we've understood to resolve disputes for hundreds of years has been to put your foot in a courtroom, right? And have someone else make a decision for you. So the concept of a codification of a process where we remove that scenario or that forum and
Yeah.
we allow the parties to re-engage in communication is somewhat foreign, right? And I think there's a bit of fear in doing that. But I think some folks have an interest in most of the states, as you can see, in endorsing the process. And I
Yeah.
think as time progresses, I think that will change.
Oh, thank you. Thank you so very much on that. So, what is your advice for potential users and people pursuing a career in collaborative law?
So I think there's trainings involved. I mean, we talked about this a little bit this offline. So I provide trainings pretty regularly during the year for folks, lawyers, and particularly other professionals to learn.
Yeah.
It tends to be it's a multi-day course in learning about sort of interest negotiation from the collaborative process, learning skills like active listening, skills of understanding how to work in a team approach to conflict resolution, different things that are involved in that process, and skill sets and doing fact scenarios and hypotheticals to practice that. There are the organizations I mentioned to you, IACP and Global Collaborative Law Council, provide those trainings as well. They're listed on the IACP website. You can see some of these trainings
Okay.
as well. And that's where I think the first start. I think sort of and I believe, if I'm correct, then it's probably greater, but the last census was about 238 practice groups here in North America.
Yeah.
So there's plenty of practice groups that people can, and there's folks. I mean, I've had the pleasure of teaching in Spain and the Netherlands and
Mhm.
other parts of Europe and the like. And so there are practice groups all over the world. And
Yeah.
so really just sort of reaching out to folks, and if there's an interest in it, and if you had exposure like yourself to
Yeah.
ADR
Yeah.
school, that's
Yeah.
a great way to do it.
Okay. Thank you. You mentioned teaching, and I'm thinking about have how do people learn about collaborative law in schools in the US?
So they do. There are
Oh,
some
really?
folks.
Is it a compulsory course or just an elective?
So I believe it's an elective course. I have some
Hmm.
colleagues here in New York that do
Hmm.
teach at some of the law schools.
Okay.
Um, I know there's a couple courses at Pace Law School here in Westchester County, New York, and in Brooklyn, my alma mater, in law school down in the city in New York City. There are folks that teach a different. I know Kevin Scudder, who you mentioned. I think he teaches a course out in Washington State.
Okay.
Folks who teach in North Carolina. So yes, there's a lot of different. David Hoffman teaches one at Harvard Law School. So there's a lot of folks who do teach at law schools these type of elective courses. I
Okay.
mean, when I went to school,
Yeah.
I took an ADR course. It's probably one of the first times that people were offering an ADR course, and now it's more commonplace.
Yeah. Thank you so very much for that. So, finally, what are the aims and objectives of Markus and Sheridan LLP?
With regard to collaborative,
Oh, with general, what?
so I mean, I have my own law firm, as you just mentioned.
Yeah.
One of my goal in talking about collaborative collaborative practice and sort of an ADR in general is really, I'm a firm believer. I'm a firm believer in people being empowered to resolve their own disputes and having support to do that. There's been obviously, thousands of folks who have had the same concept, that the idea of, the sort of oath we took as attorneys is not only to be an advocate, but to be a counselor at law. And so one of the roles of that is really actually, you take that oath, is really helping people work to solve their own problems. The reason they're mostly coming to you is because they haven't been able to do that. And to exacerbate that problem is really antithesis of what I took an oath to do. And so my sort of mission and other folks, and particularly my partner in this law firm, is really to promote the use of collaborative practice to help people resolve disputes. It's something I talk about. I have this tool as an offering when clients call me. I train folks on it so they can learn to offer it to their clients. And it's sort of, we've hit the tip of the iceberg, and we'll continue to kind of grow, make that iceberg a little as bigger as time goes on. And I think I don't look at it more of going uphill. I look at it's really going to be something that's engendered by society over time. Court is expensive. Litigation it's a constraint on time, not only cost of money, but the emotion involved in litigation is tremendous. And having something that can short circuit that can help restore that communication, that can narrow the issues and help parties resolve their own disputes is really great.
Yeah. Well, thank you so very much, Mark, for offering a very detailed overview on collaborative law.
Sure.
It has been a masterclass. Thank you so very much. And I believe that from all the advantages you've listed on this show, that potential users would embrace what you've said and opt for collaborative law whenever the need arises. Thank you so very much for coming on the show. I'm so grateful. And well, to my listeners, thank you so much for your constant support. Stay tuned, same time, for Collaborative Law US Perspective. Bye, take care.
Thanks very much, Noi. Appreciate it.